Good day, sir. I'm Jetro Clyde Balinton, and Article 40, Aggravating Circumstances. The following are aggravating circumstances. Number 1 is that advantage be taken by the offender of his public position. Requisites. Number 1, the offender is a public officer. Number 2, the commission of the crime would not have been possible without the powers, resources, and influence of the office he holds. Essentials, public officers use the influence to prestige of ascendancy, which his office gives him as the means by which he realizes his purpose. Failure in official is tantamount to abusing of office. Wearing of uniform is immaterial. What matters is the proof that he indeed took advantage of his position. Number 2, that the crime be committed in contempt or with insult to public authorities. Requisites. Number 1, the offender knows that the public authority is present. Number 2, the public authority is engaged in the exercise of his functions. Number 3, the public authority is not a victim of the crime. Number 4 is the public authorities' presence did not prevent the criminal act. Example, Juan and Pedro are quarreling, and the municipal mayor upon passing by attempts to stop them, and with understanding the intervention and the presence of the mayor, Juan and Pedro continue to quarrel until Juan succeeds in killing Pedro. Person in authority, public authority who is directly vested with jurisdiction has the power to govern and execute the laws. Examples, persons and in authority. Number 1, governor. Number 2, mayor. Number 3, barangay captain. Number 4, councilors. Number 5, government agents. Number 6 is chief of police. Rule not applicable when committed in the presence of a mere agent, subordinate public officer, charged with the maintenance of public order and protection and security of life and property. Example, barrio vice lieutenant, barrio councilman. Number 3 is the act be committed. Number 1, with insult or in disregard of the respect due to the offended party on account of his A. rank, B. age, C. sex, or that it be committed in the dwelling of the offended party if the latter has not given provocation. Circumstances may be taken into account only in the crimes against persons or honor. It cannot be invoked in crimes against property. Rank refers to the high social position or standing by which to determine one's pay and emoluments in any scale of comparison within a position. Age. The circumstance of lack of respect due to age applies in the case where the victim is of tender age as well as of old age. And sex refers to the female sex to the male sex, not applicable. Number 1, when the offender act with passion or obfuscation. Number 2, there exists a relation between the offender and the victim, but in cases of the divorce, decrease where there is a direct bearing on their child is applicable. Number 3 is the condition of being a woman is indispensable in the commission of crime. Example, parricide, rape, abduction. Requisites of disregard to rank, age, or sex. Number 1 is crimes must be against the victim's persons or his honor. Number 2 is there is a deliberate intent to offend or insult the respect due to the victim ranks, age, or sex. Disregard to rank, age, sex, or age, rank, age, or sex is observed with treachery or abuse of strength. Dwelling must be a building of structure exclusively used for rest and confront, combination house and store not included. Number 1 is the temporary, as in the case of guest in the house of bed spacer. Number 2 is basis for this is the sanctity of privacy the law accords to human abode. Dwelling includes dependencies, the foot of the staircase, and the enclosure under the house. Elements of aggravating circumstances of dwelling. Number 1 is crime occurred in the dwelling of the victim. Number 2 is the provocation on the part of the victim. Requisites for provocation all must concur. Number 1 is given by the owner of the dwelling. Number 2 is sufficient. Number 3 is immediate to the commission of the crime. When the dwelling may and may not be considered. When it may be considered is although the offender fired a shot from the outside the house as long as his victim was inside. Number 2 is even if the killing took place outside the dwelling, so long as the commission began inside the dwelling. Number 3 is when adultery is committed in the dwelling of the husband, even if it is also the dwelling of the wife, it is still aggravating because she and her paramour committed an grave offense to the head of the house. And number 4 is in robbery of violence against persons, robbery with homicide, abduction, or illegal detention. Number 6 is if the offended party has given provocation. And when it may not be considered, number 1 is the victim is outside his or her dwelling. Number 2 is if offended party are not occupants of the said dwelling. And another dwelling may be considered is if both the offender and the offended party are occupants of the same dwelling. And last one is in robbery with force upon things is inherent. And number 4 is the act be committed with 1. Abuse of confidence, 2. Obvious ungratefulness. Requisites of abuse of confidence is A. Offended party has trusted the offender. B. Offender abused such trust. And C. Abuse of confidence facilitated the commission of the crime. And requisites of obvious ungratefulness. A is ungratefulness must be obvious, that is there must be something which the offender should owe the victim a debt of gratitude for. Note, robbery or theft committed by the visitor in the house of the offended party is aggravated by obvious ungratefulness. An example, a jealous lover already determined to kill his sweetheart invited for a ride, and during the ride, he stabbed her. Abuse of confidence is inherent in number 1 is malversation, number 2 is qualified theft, number 3 is estafa by conversion, and number 4 is misappropriation, and number 5 is qualified seduction. And number 5 is that the crime must be committed in the palace of the chief executive or in his presence, or when public authorities are engaged in the discharge of their duties, or in a place dedicated to religious worship. Requirements of the aggravating circumstances of the public office. Number 1 is polling present in a public office during election day. And nature of public office should be taken into account, like a police station which is on duty 24 hours a day. And number 3 is a place of the commission of the felony. If it is Malacanang Palace or a church, is aggravating regardless of whether state or official function are being held. As regards other places where public authorities are engaged in the discharge of their duties, there must be some performance of public functions. And last is the offender must have intention to commit a crime when he entered the place. And requisites for aggravating circumstances of place or of worship. Number 1 is the crime occurred in the public office. Number 2 is public authorities are actually performing their public duties. And number 1 is the crime occurred in the palace dedicated to the worship of God regardless of religion. And number 2 is offender must have decided to commit the crime when he entered the place of worship. And when paragraph 2 and 5 of Article 14 are applicable. Committed in the presence of chief executive in the presidential palace or a place of worship. And public authorities are performing of their duties when the crime is committed. When the crime is committed in the public office, the officer must be performing his duties exempt in the presidential palace. Public authority may be the offended party and committed in the contempt of the public authority and outside of the palace or office, and public authority is not be the offended party. And 6A is that the crime be committed, number 1 in the nightmare, number 2 or 2 in an uninhabited place, and 3 by a band whenever such circumstances may be facilitate the commission of the offense. Nightmare, nighttime, uninhabited place or by a bang aggravating when impunity means to prevent the accused being recognized or to secure himself against detection or punishment. Nighttime begins at the end of dusk and ending at dawn from sunset to sunrise. Uninhabited place, one where there are no houses at all, a place at a considerable distance from town where the houses are scattered at a great distance from each other. And number 1 is it is facilitated by the commission of the crime. Number 2 is officially sought for by the offender to ensure the commission of the crime or for the purpose of impunity. Number 3 is when the offender took the advantage thereof for the purpose of impunity. And number 4 is commission of the crime must have begun and accomplished at night time. And number 1 is commission of the crime must begin and be accomplished in night time. Number 2, when the place of the crime is illuminated by light, nighttime is not aggravating. And number 3 is absorbed by treachery. Requisites. Number 1 is place facilitated the commission or omission of the crime. And number 2 is deliberately sought and not incidental to the commission or omission of the crime. Number 3 is taken advantage of for the purpose of impunity. And what should be considered here, whether in the place of the commission of the offense, there was a reasonable possibility of the victim receiving some help. And 6B is whenever more than 3 armed malefactors shall have acted together in the commission of an offense, it shall be deemed to have been committed by a band. And requisites. Number 1 is if one of the 4 armed malefactors is a principal by inducement, they do not form a band because it is undoubtedly connected that he had no direct participation. And number 2, band is inherent in robbery committed in a band and brigandage. And number 4 is it is not considered in the crime of rape. Number 5 is it has applied in treason in robbery with homicide. And facilitated the commission of the crime, deliberately sought. And number 3 is taken advantage of for the purpose of impunity. And number 4 is there must be 4 and or more armed men. And number 7 is that the crime committed on the occasion of a conflagration, shipwreck, earthquake, epidemic, or other calamity or misfortune. And requisites committed when there is a calamity or misfortune. And number 1 is conflagration. Number 2 is shipwreck. And number 3 is epidemic. And 2, offender took advantage of the state of the confusion or chaotic condition from such misfortune. And basis, commission of the crime adds to the suffering by taking advantage of the misfortune. And bullet 2 is based on time. And bullet 3 is offender must take advantage of the calamity or misfortune. And distinction between paragraph 7 and 12 of Article 14. And committed during a calamity or misfortune, and committed with the use of wasteful means. And crime is committed during any of calamities, and crime is committed by using fire, inundation, explosion, or other wasteful means. And number 8 is that the crime be committed with the aid of one armed man or two persons who ensure or afford impunity. And based on the means and ways requisites, number 1 is that armed men or persons took part in the commission of the crime directly or indirectly. And number 2 is that the accused availed himself of their aid or relied upon them when the crimes was committed. Exceptions. Number 1 is when both the attacking party and the attacking party attack were equally armed. And number 2 is not present when the accused as well as those who cooperated with him in the commission of the crime acted under the same plan and for the same purpose. And number 3 is casual presence, or when the offender did not avail himself of any of their aid nor did not unknowingly count upon their assistance in the commission of the crime. And with the aid of armed men, presence if one of the offenders merely relied on their aid, actual aid is not necessary. By a band is requires more than 3 armed malefactors who all acted together of the in the commission of an offense. If there are more than 3 armed men, aid of armed men is absorbed in the employment of a band. So, number 9 is that the accused is the recidivist. Recidivist is one who at the time of his trial for one's crime shall have been previously convicted by final judgment of another crime embraced in the same title of RPC. Basis: greater perversity of the offender as shown by his inclination to commit crimes. The requisites. Number 1 is offender is on trial for an offense. Number 2 is he was previously convicted by a final judgment of another crime. Number 3 is that both the first and the second offense are embraced in the same title of the RPC. And number 4 is the offender is convicted of the new offense. And recidivism is must be taken into account no matter how many years have event between the first and second felonies. Pardon does not obliterate the fact that the accused was a recidivist, but amnesty extinguishes the penalty and its effects. And to prove recidivism, it must be alleged in the information and with certified copies of the sentences rendered against the accused. Exemption: if the accused does not object and when he admit in his confessions on the witnesses stands. And number 10 is that the offender has been previously punished for an offense to which the law attaches an equal or greater penalty, or for two or more crimes to which it attaches a lighter penalty. So, reiteration or habitually, it is essential that the offender be previously punished. That is, he has served sentences. Par 10 speaks of penalty attached of the offense, not the penalty actually imposed. So, reiteration, necessary that the offender shall have served out his sentence for the first sentence, and previous and subsequent offenses must not be embraced in the same title of the code, and not always an aggravating circumstances. In recidivism, not enough that final judgment has been rendered in the first offense, same title, and always aggravating, and habitually delinquency. When a person's within a period of 10 years from the date of his release or last conviction of the crime of serious or less serious physical injuries, robbery, theft, estafa, or falsification, is found guilty of any of said crimes a third time or oftener. And quasi-recidivism is any person who shall commit a felony after having been convicted by a final judgment before beginning to serve such sentence, or while serving the same, shall be punished by the maximum period of penalty prescribed by law for the new felony. And number 4 is 4 forms of repetition. Number 1 is recidivism, generic, and number 2 is reiteration or habitually is generic. Number 3 is multiple recidivism and habitually delinquency, extraordinary aggravating, and number 4 is quasi-recidivism, special aggravating. So, number 11, that the crime be committed in the consideration of a price, reward, or promise. Requisites: at least 2 principles. Number 1 is the principle by inducement, and number 2 is a principle by direct participation. Number 3 is the price, reward, or promise should be previous and in consideration of commission of the criminal act, applicable to both principles. Number 12 is that the crime be committed by means of inundation, fire, poison, explosions, stranding a vessel, or intentional damage thereto, or derailment of the locomotive, or by use of any other artifice involving great waste or ruin. And requisites: the wasteful means were used by the offender to accomplish a criminal purpose. 13. That the act be committed with evident premeditation. Essence of premeditation: the execution of criminal act must be preceded by cool thought and reflection upon the resolution to carry out the criminal intent during space of time sufficient to arrive at a calm judgment. And requisites is number 1 is the time when the offender determined to commit the crime. And number 2 is an act manifestly indicating that the culprit has clung to his determination. Number 3 is a sufficient lapse of time between the determination and execution to allow him to reflect upon the consequences of his act and to allow his conscience to overcome the resolution of his will. And bullet 1 is conspiracy generally presupposes premeditation. And bullet 2 is the victim is different from the intended. Premeditation is not aggravating. Also, it is not necessary that there is a plan to kill a particular person for premeditation to exist. Plan to kill first 2 persons, 1 meets general attack on a village for as long as it was planned. Bullet 3 is the premeditation must be based upon external acts and must be evident, not merely suspected, indicating the deliberate planning. And last bullet is evident premeditation is inherent in robbery, adultery, theft, estafa, falsification, and etc. And number 14 is that 1 craft, 2 fraud, or 3 disguise be employed. Craft involves the intellectual trickery and cunning on the part of the accused. It is employed as a scheme in the execution of the crime. Accused pretended to the members to be members of the constabulary. Accused in order to perpetrate a rape, use chocolates containing drugs. And fraud involves insidious words or machinations used to induce victim to act in a manner which would enable the offender to carry out his designs. And as a distinguished from craft, which involves acts done order not arouse the suspicion of the victim. Fraud involves a direct inducement or inducement through entrapping or beguiling language or machinations. Disguise resorting to any advice to conceal identity. Purpose of concealing identity is must. Distinction between craft, fraud, and disguise. Craft involves the intellectual trickery and cunning to arouse suspicion of the victim. Fraud involves the use of direct inducement by insidious words or machinations. And disguise involves the use of device to conceal identity. Requisite: the offender must have actually taken advantage of craft, fraud, or disguise to facilitate the commission of the crime. Inherent in estafa and falsification. 15. That 1 advantage be taken of superior strength, or 2 means be employed to weaken the defense. And to purposely use executive force out of the proportion to the means of defense available to the person's attack. Requisites of means to weaken defense. Number 1 is means were purposely sought to weaken of defense of the victim to resist the assault. Number 2 is the means used must not totally eliminate possible defense to the victim, otherwise it will fall under treachery. Bullet 1 is to weaken the defense, illustrated in the case where one struggling with another suddenly throws a clock over the head of his opponent, and while in the said situation he wounds or kills him. Other means of weakening the defense would be intoxication or dissembling through the sense, casting sand upon another eyes. So number 1 is superiority may arise from aggressor sex a weapon or number as compared to that of the victim. Accused attack an unarmed girl with a knife. 3 men stabbed to death the female victim. Number 2 is no advantage of superior strength when when one who attacks is overcome with passion of obfuscation, or when quarrel arose unexpectedly and the fatal blow was struck while the victim and accused were struggling. And number 3 is versus by a band. Circumstance of abuse of superior strength. What is taken into account is not the number of aggressors, nor the fact that they are armed, but their relative physical might vis-a-vis the offended party. And number 16 is the act be committed with treachery, alevosía. And treachery, when the offender commits any of the crime against the persons, employing means, methods, or forms in the execution thereof, which tend directly and especially to ensure its execution without risk to himself arising from the defense which the offended party might make. Requisites. Number 1 is that the time of the attack, the victim was not in the position to defend himself. And number 2 is that the offender consciously adapted the particular means, method, or form of attack employed by him. Treachery can be considered when there is no evidence that the accused prior to the moment of killing resolved to commit the crime, or there is no proof that death of the victim was the result of meditation, calculation, or reflection. Examples: victim asleep, half awake or just awake, victim grappling or being held stuck from behind. And bullet 1 is, but treachery may exist even attacks is face to face, as long as the victim was not given any chance to prepare defense. And number 1 is that not exist if the accused gave the deceased chance to prepare, or there was warning given, or that is preceded by a heating argument. Number 2 is there is always treachery in killing of child. Number 3 is generally characterized by the deliberate and sudden and unexpected attack of the victim from behind without any warning of, without giving the victim an opportunity to defend himself. And treachery. Treachery means method of forms are employed by the offender to make it possible or hard for the offended party to put any sort of resistance. Abuse of superior strength. Offender does not employ means, methods, or forms of attack. He only takes advantage of his superior strength. And means employed to weaken defense. Means are employed, but it is only materially weaken the resisting power of the offended party. And bullet 1 is another bullet is where there is conspiracy, treachery is considered against all of the offenders. And last bullet for 16, treachery absorbs abuse of strength, aid of armed men by a band, and means to weaken the defense. And number 17 is that means be employed or circumstances brought about the add ignominy to the natural effects of the acts. Ignominy is a circumstance pertaining to a moral order, which adds disgrace and obloquy to the material injury caused by the crime. Applicable to the crimes against chastity, rape included, less serious physical injuries, or light or grave coercion and murder. And requisites. Crime must be against chastity, less serious physical injuries, light or grave coercion, and murder. Number 2 is the circumstances made the crime more humiliating and shameful of the victim. Examples: the accused embraced and kissed the offended party, not out of lust but out of anger in front of many people. Raped in front of the husband. Raped successively by 5 men. And tend to make the effects of the crime more humiliating. Ignominy, not present where the victim was already dead when such acts were committed against his body or persons. And number 18 is that the crime be committed after an unlawful entry. Unlawful entry is when an entrance is affected by a way not intended for the purpose, meant to effect the entrance, not exit. Bullet 1 is why aggravating. Who acts not respecting the walls erected by men to guard their property and provide for their personality safety shows greater perversity, a greater audacity, and hence the law punishes him with more severity. Example: rapist gains entrance through the window. Inherent: trespass to dwelling, robbery with force upon things, and robbery with violence or intimidation against persons. And 19 is that as a means to the commission of the crime, a wall, roof, door, or window be broken. Requisites: number 1 is a wall, roof, window, or door was broken. Number 2 is they were broken to effect entrance. And bullet 1 applicable only if such acts were done by the offender to effect entrance. And bullet 2 breaking unlawful in the following instances. Number 1 is an officer in order to make an arrest may break open a door or window of any building in the which a person's arrested is or reasonably be believed to be. And number 2 is an officer, if refused admittance, may break open any door or window to execute the search warrant of or deliberate himself. Number 20 is that the crime be committed 1 with the aid of persons under 15 years of age, or 2 is by means of motor vehicles, airship, or other similar means. Reason for number 1 is to repress so far as possible the frequent practice resorted to by professional criminals to avail themselves of minors taking advantage of their responsibility. Remember that the minor are given leniency when they committed a crime. Example: 1 instructed a 14-year-old to climb up the fence and open the gate for him so that he may rob the house. Reason 2 is to counteract the great facilities found in the modern criminals in said means to commit the crime and flee the abscond. Once the same is committed, necessary that the motor vehicle be important tool to the consummation of the crime. Bicycles are not included. Example: Juan and Pedro in committing theft used truck to haul the appliances from the mansion. And 21, that the wrong done in the commission of the crime be deliberately augmented by causing other wrong necessary for its commission. Cruelty: when the culprit enjoys the delights of making his victim suffer slow and gradually, causing him unnecessary physical pain in the consummation of the criminal act. Cruelty cannot be presumed nor merely inferred from the body of the deceased has been proven. Number 1 is mere plurality of the words do not show cruelty. Number 2 is no cruelty when the other wrong was done after the victim was dead. Requisites. Number 1 is the injury caused by deliberately increased by causing other wrong. Number 2 is that the other wrong be unnecessary for execution of the purpose of the offender. Ignominy. Moral suffering subjected to humiliation. Cruelty, physical suffering. And in Article 14 of Revised Penal Code in the Philippines, all the topics that I recite is about the determining the penalties for crimes. It considers the different factors can make the punishment more or less grave. These factors include the things like the intention of the offender, whether they voluntarily turned themselves in, and if they were underage when the crime was committed. The purpose of Article 14 to ensure that the punishment fits the crime and takes into account specific circumstances that may affect the offender's liability. And let's proceed to the Article 15. Article 15, alternative circumstances. Alternative circumstances are those which must be taken into consideration as aggravating or mitigating according to the nature and effects of the crime and the other conditions attending its commissions. They are relationship, intoxication, and the degree of instruction and education of the offender. The alternative circumstance of the relationship shall be taken into consideration when the offended party in the spouse, ascendants, descendants, legitimate, natural, or adopted brother or sister, or relative by affinity in the same degrees of the offender. The intoxication of the offender shall be taken into consideration as a mitigating circumstances when the offender was committed a felony in the state of intoxication. If the same is not habitually or subsequent to plan to commit a said felony, but when the intoxication is habitually or intentional, shall be considered as an aggravating circumstances. So, alternative circumstances are those which must be taken into consideration as aggravating or mitigating according to the nature and effects of the crime and the other condition attending its commissions. And they are relationships taken into the consideration when the offended party is a spouse, ascendants, descendants, legitimate, natural, or adopted brother or sister, or relative by affinity in the same degree of the offender. Intoxication. Intoxication mitigating when the offender has committed a felony in the state of the intoxication if the same habitually subsequent to plan to commit the said felony. Aggravating is habitual or intentional. Number 3 is degree of instructions and education of the offender. So number 1 is relationships, mitigating circumstances in the crimes against property, robbery, usurpation, fraudulent insolvency, arson. Exception, Article 332 of CC, no criminal liability, civil liability, only the crimes of theft, swindling, or malicious mischief committed or caused mutually by spouse, ascendants, descendants, or relatives by affinity. Also brothers and sisters, brother-in-law or sisters-in-law, if living together. It becomes an exempting circumstance. But in the aggravating circumstances, in the crimes against persons, in the case where the offender or when the offender and the offended party are relatives of same level, as killing a brother, adopted brother, or half-brother. Always aggravating in crimes against chastity. And intoxication. Mitigating circumstances. A. If intoxication is habitually. And B is intoxication is subsequent to the plan to commit a felony. In aggravating circumstance, A. If intoxication is habitual, such habit be actual and confirmed. B. If it's intentional subsequent to plan to commit a felony. Must show that that he has taken such quantity so as to blur his reason and deprive him of a certain degree of control. Habitual drunkard and is given to inebriety or the excessive use of intoxicating drinks. Habitual drunkenness must be shown to be an actual and confirmed habit of the offender, but not necessary of daily occurrence. Degree of instructions and education. Mitigating circumstances. Low degree of instructions, education, or lack of it. Because he does not fully realize the consequences of the criminal act, not just a mere illiteracy but lack of intelligence. Aggravating circumstances. High degree of instruction and education. Offender avails himself and learning in committing the offense. And determined by the court must consider the circumstances of lack of instructions. Exemption, not mitigating. So number 1 against crimes against property. Number 2 is crimes against chastity, rape included. And number 3 is crimes of treason. So the key points of Article 15 is number 1 is the relationships and intoxication and degree of instruction and education. So in relation, it talks about your family or kadugo. And intoxication, it is focusing on the habitually or not. And in the degree of instructions and education is they are using their knowledge or their sa nahuman pa, they're using that knowledge to commit a criminal act. The importance of this article is to determine determine the circumstances if it is mitigating or aggravating circumstances. So that's all, and thank you for watching and have a good day. Thank you and mabuhay.